This is Hidden Killers with Tony Bruschi.
If you walked into the Los Angeles courtroom on April 17th expecting a turning point in one of the most infamous murder cases in American history, you weren't alone. Reporters, legal analysts, and even some old-school true crime junkies were ready to witness something rare, possibly historic. For the first time in over 3 decades, there was a very real possibility that Erik and Lyle Menendez might get a shot at parole, not a retrial, not a pardon, but something the justice system hasn't offered them since they were locked away as teenagers, a second chance. But by the time the session wrapped, it wasn't freedom anyone was talking about. It was frustration. A courtroom that was supposed to be focused on redemption ended up bogged down in a bureaucratic mess. The hearing didn't crash and burn exactly. It stalled. Like a car in neutral, engine running, everyone staring at each other wondering who forgot the keys. And it all came down to a single document, a risk assessment report from the California Parole Board that landed like a legal grenade right in the middle of the room. To understand the impact, you need to know what this hearing was actually supposed to be. Under California's newer sentencing reform laws, judges now have the power to revisit life without parole sentences if it's determined that justice would be better served by something less permanent. For Erik and Lyle Menendez, who were 18 and 21 when they shot their parents in 1989, that change in law opened the door to a resentencing, and with it, the possibility of parole. The Menendez brothers' legal team, led by veteran defense attorney Mark Garagos, was geared up to argue that their clients had not only changed, but had spent over 30 years doing the kind of rehabilitation the system supposedly wants from people it incarcerates. They've participated in inmate education programs, mentored younger prisoners, and stayed out of trouble. And more to the point, their defense was going to highlight that these were young men at the time of the murders who, they argue, were reacting to years of horrific abuse at the hands of their father, José Menendez. Whether you believe that or not, the April 17th hearing was set to be the moment their team finally made that case in front of a judge. But that's not what happened. Instead, just before things were set to begin, the Los Angeles District Attorney's Office, now under the leadership of Nathan Hochman, raised their hand and essentially said, "Hold up. We just got a key piece of information, and we haven't had time to read it." That information was the Parole Board's comprehensive risk assessment of the Menendez brothers. It had been requested by Governor Gavin Newsom, part of his own ongoing review of the brothers' Clemency request. In other words, while the court was getting ready to decide if the brothers deserved a reduced sentence, the governor was also doing his own homework to determine if they were safe to release at all. Now, normally that kind of review might happen behind the scenes or on a totally separate track, but here, the parole board's findings ended up being dropped on the prosecution's desk at the 11th hour, and that timing turned out to be everything. Prosecutors told the judge that they hadn't had a chance to review the document thoroughly, and they asked for a continuance. That by itself might have been met with a shrug from the defense. It happens. Court schedules shift, but then things got sticky. Mark Garagos, clearly blindsided, objected to the delay. He argued that the hearing had been planned for weeks, and any holdup, especially one involving a document the defense hadn't even seen, was deeply unfair. That's when the real problem surfaced. The prosecution had already been given access to the report and hadn't shared it. The defense hadn't gotten a copy. Let that sink in. In a hearing that could literally determine whether two people spend the rest of their lives behind bars or get a second chance at freedom, one side had access to crucial information while the other didn't. Garagos, who's never been one to mince words, was livid. He pointed out that not only was this an ambush tactic, but it reeked of political gamesmanship. And if you know the history between him and the Los Angeles DA's office, this wasn't just courtroom banter. It was a declaration of war. The courtroom atmosphere shifted from tense to borderline hostile. Allegations of misconduct started flying. Garagos even hinted that he might file to have the DA's office disqualified from the case entirely, citing bias and unequal treatment. Meanwhile, Judge Michael Jessup, who was overseeing the proceedings, sat at the center of this chaos. And while he didn't take the bait on the theatrics, he made one thing clear: fairness matters. Jessup ruled that it wouldn't be right to move forward until both sides had access to the same materials. As a result, he pushed the hearing to a later date in May. And that was it. No testimony, no rulings on resentencing, no arguments about abuse, rehabilitation, or public safety. Just an empty courtroom with a handful of angry attorneys, a pair of aging defendants watching remotely from prison, and a blown opportunity to resolve a case that's lingered in the national consciousness for over 3 decades. It's hard to overstate how rare this kind of legal limbo is. We're not talking about a minor delay in a traffic ticket hearing. This was a resentencing hearing for 2 men convicted of one of the most sensational double murders of the 20th century. The fact that it was derailed by a late-arriving document, one that should have been shared with both sides, felt less like a clerical hiccup and more like a warning sign of deeper dysfunction. And if you're thinking this whole thing feels suspiciously like a setup for a longer, uglier fight, you're not wrong. Because what happened on April 17th wasn't just a delay. It was the opening salvo in what's shaping up to be a multi-front legal war. One that's going to pull in questions about prosecutorial conduct, transparency, victims' rights, the purpose of rehabilitation, and yes, whether Erik and Lyle Menendez are still being judged more for who they were in 1989 than for who they've become since. So as the dust settles and the attorneys regroup for round 2, one thing is clear: this isn't over. Not even close. The next time these parties meet in court, it won't just be about whether a hearing should go forward. It'll be about who gets to prosecute it, what evidence can be used, and whether the system is actually capable of giving these 2 men a fair shot under the laws we have today. 35 years after the Menendez brothers gunned down their parents in the den of their Beverly Hills mansion, the courtroom battle isn't about what happened on that August night in 1989. That part is set in stone. José and Kitty Menendez were shot multiple times with shotguns. Erik and Lyle confessed. They were convicted. Case closed, right? Not quite, because the question on the table in 2025 isn't whether they did it. It's whether what they did and why they did it still justifies keeping them behind bars for life with zero possibility of parole. And that's where things get complicated fast. At the heart of the resentencing push is a law that didn't exist when the Menendez brothers were sentenced. California's resentencing reform statutes, most recently expanded under Assembly Bill 600 and Senate Bill 1437. These laws give judges discretion to reevaluate long-term sentences, especially life without parole, if the court believes that continued incarceration no longer serves justice. It's a shift that reflects evolving views on youth, trauma, and rehabilitation. The idea is that people, especially people who were young when they committed their crimes, can change. And that if they do, the law shouldn't treat them the same way it treats someone who hasn't. Mark Garagos, never one to leave room for subtlety, is leaning all the way into that premise. He's made it clear that Erik and Lyle Menendez are not the same people they were in the late 80s. Back then, he argues, they were 2 terrified kids, psychologically broken by years of sexual and emotional abuse. They weren't monsters. They were victims pushed to the brink. And in the decades since, they've matured, taken accountability, and rebuilt themselves inside the walls of California's prison system. Garagos points to their clean disciplinary records, their involvement in prisoner education programs, and their mentorship of other inmates as evidence that they're not just rehabilitated, they become part of the solution. But if you're expecting the prosecution to nod along with any of that, you haven't been paying attention. The Los Angeles District Attorney's Office, now helmed by Nathan Hochman, is taking a firm stance. The Menendez brothers weren't acting out of trauma. They were acting out of greed. Their parents were planning to cut them off financially. Lyle had flunked out of college. Erik had been caught in a cheating scandal. According to prosecutors, the brothers feared their privileged lifestyle was about to end, and they decided to eliminate the obstacle permanently. The DA's team isn't just sticking to that theory, they're doubling down on it. During pre-hearing arguments, Deputy DA Habib Balian reiterated that the killings were premeditated and methodical. The brothers bought shotguns, went to the movies as an alibi, and then emptied both barrels into their sleeping parents. Twice. That wasn't panic, he said. That wasn't fear. That was planning. The prosecution's position is that no matter how much time has passed or what behavior the brothers have shown in prison, the original motive and the calculated way they carried it out still rules the day. And they're skeptical, to say the least, about the abuse claims that have come to dominate public conversation around the case. In their eyes, those allegations didn't appear until the defense needed them to. Prosecutors argue that if there was a long, documented history of abuse, anyone should have said something before the bullets flew. It's worth noting here that the judge presiding over this resentencing decision, Michael Jessup, isn't being asked to retry the case. He's not re-examining guilt or innocence. His job is to decide whether, under modern California law, a life without parole sentence is still appropriate for two men who were technically still adolescents, and they committed their crimes, and who, by most accounts, have transformed significantly since. And that brings us to the philosophical rift that's powering this entire fight. On one side, you have a legal theory rooted in retribution. A life without parole sentence is supposed to send a message that some crimes are so heinous, so devoid of justification, that the people who commit them should never re-enter society, no matter what. That's the foundation the prosecution is standing on. The Menendez brothers killed their parents, not in a struggle, not in the heat of the moment, but in a planned, deliberate execution that in their eyes is unforgivable. On the other side is a view that's more restorative, that acknowledges the horror of the crime, but also asks whether a person can evolve past their worst moment. That considers the science of adolescent brain development, the impact of sustained trauma, and the real-life stories of people who enter prison angry, broken, and dangerous, and leave decades later as something entirely different. The law that makes resentencing possible doesn't automatically tip the scale toward one view or the other. It leaves the decision up to the judge. And that's why every move in this case is being scrutinized with surgical precision. Every behavior the brothers have shown in prison, every detail about their childhood, every word from the original trial transcripts, all of it is being picked apart in a kind of retroactive moral audit. Not to prove what happened, but to decide what to do about it now. The defense has argued that this is precisely the kind of case these new laws were meant to address, that keeping someone locked away without parole even after they've demonstrated reform isn't justice. It's inertia. Garagos has also taken issue with the idea that the brothers haven't taken accountability, noting that both admitted to the killings and explained their motives under oath. Whether you believe those motives or not, he says, the law doesn't require perfection, it requires progress. The prosecution, meanwhile, says that so-called progress means nothing without remorse, real remorse. And to them, that means not just saying, I did it, but saying, I was wrong to do it. They don't believe the Menendez brothers have crossed that line, and until they do, they argue, no amount of good behavior in prison should open the door to parole. It's a brutal clash, not just of facts, but of values. What's the purpose of prison? Is it punishment, protection, rehabilitation, a mix of all three? And what happens when someone checks one of those boxes but not the others? The courtroom hasn't answered those questions yet. In fact, the April 17th delay only sharpened them. But when Judge Jessup finally resumes this hearing, he'll be forced to draw a line. Not between guilt and innocence, that ship sailed long ago, but between a justice system that locks people away and leaves them there, and one that dares to reconsider. For the first time in over 3 decades, Erik and Lyle Menendez aren't just waiting on one court's decision. They're standing at the intersection of 3 separate high-stakes legal roads. Each one could change their future completely. And the kicker? All 3 are moving at the same time. The Menendez brothers have spent most of their adult lives behind bars for one of the most notorious crimes of the 20th century. But in 2025, they're navigating a legal storm with more moving parts than they've ever faced before. Let's start with the closest thing to the front line, the courtroom of Judge Michael Jesich in Los Angeles. After the delayed resentencing hearing on April 17th, all eyes shifted to the next critical court date, May 9th. That's when Judge Jesich is expected to rule on two procedural but potentially game-changing issues. First, whether the Los Angeles District Attorney's Office can continue prosecuting the case at all. Second, whether the controversial risk assessment report commissioned by Governor Newsom and delivered by the Parole Board can be admitted into the resentencing record. On the surface, those might sound like legal housekeeping items, but they're not. They cut straight to the core of fairness and transparency in the Menendez resentencing process. The motion to remove the DA's office is based on defense claims that the new district attorney, Nathan Hochman, has demonstrated personal bias. Garagos has argued that Hochman's reversal of his predecessor's decision to support resentencing was politically motivated and that his team's failure to share key documents like the risk report was part of a pattern of adversarial conduct, not just legal oversight. If the judge agrees and the prosecution gets bounced from the case, that could throw the entire process into uncharted territory. A new neutral prosecutor would have to be appointed, someone without the baggage, without the old narratives, without the historical investment in keeping the brothers locked away forever. That alone could change the tone and trajectory of the hearing. Then there's the matter of the risk report. It was commissioned by the governor as part of a clemency review, but landed squarely in the resentencing arena. The prosecution says it's crucial. The defense says it's unfair, especially since they weren't allowed to see it at first. If the judge decides the report should be excluded, that might limit the prosecution's ability to argue that the brothers still pose a danger. But if it's admitted, it becomes a key piece of the puzzle, potentially influencing not just the judge's resentencing decision, but public perception of the entire case. Now, assuming those issues are resolved and the court moves forward, the judge still has to make the central call. Should Erik and Lyle Menendez continue serving life without parole, or should their sentences be modified to 50 years to life? If it's the latter, they'd be immediately eligible for parole, not guaranteed release, just the chance to make their case to the Parole Board, something they've never had in 35 years. And that brings us to legal pathway number 2, the governor's clemency process. While the resentencing hearing plays out in court, California Governor Gavin Newsom is conducting his own independent review of the Menendez brothers' case. He's asked the state parole board to evaluate whether Erik and Lyle pose a public safety risk if released. That hearing is scheduled for June 13th. The board's job is to assess things like their prison behavior, their level of remorse, any ongoing risk factors, and the broader context of the crime and its aftermath. After that, the board submits a recommendation to the governor. It's important to understand that this clemency track is not bound by the resentencing outcome. Newsom could, in theory, grant clemency even if the judge denies resentencing. He could reduce their sentences, commute them, or recommend parole eligibility on separate grounds. The reverse is also true. The judge could resentence them, and the parole board could still decide they're not safe to release. These two paths are legally distinct, but the timing means they're running side by side, influencing one another in real time. This is where politics, public pressure, and media narratives start to matter more. A governor can weigh factors that judges can't, like public sentiment, historical patterns, or the cultural impact of a case. That doesn't mean it's all optics, but let's be honest, clemency isn't just a legal move, it's a legacy move. And Newsom knows the Menendez case comes with baggage. It's loaded with tabloid history, internet mythology, and now a younger generation that's rediscovered the case on social media and sees it in a whole new light. Still, the governor hasn't made any public promises. He's asked for the data. He's waiting for the report. But the fact that he initiated this process at all, that he asked the parole board to do a full-scale risk assessment, is a signal. He's taking it seriously, and that alone is new. But even beyond the courtroom and the governor's office, there's a third legal path unfolding that might be the most dramatic of all. A motion for a new trial. Not a resentencing, not clemency. A full-on attempt to overturn the original convictions based on newly discovered evidence. At the center of this motion are two key pieces of information. First, a letter Erik Menendez wrote to a cousin in 1988, nearly a year before the murders, describing in disturbing detail the sexual abuse he allegedly endured at the hands of his father. The letter had been forgotten, lost, or ignored, depending on who you ask, for decades. But when it resurfaced in 2023, it offered potential corroboration for the brothers' original claim that they weren't just spoiled rich kids snapping under pressure, but long-term abuse victims pushed past the edge. The second piece of new evidence came from outside the family entirely. A sworn affidavit from Roy Rosselló, a former member of the boy band Menudo, who alleged that José Menendez sexually assaulted him in the 1980s, years before the murders, and with no direct connection to the Menendez family itself. If true, this testimony could support the claim that José Menendez had a pattern of predatory behavior, lending credibility to the abuse defense that was so heavily doubted during the original trials. The motion argues that this new evidence, neither of which was available to the defense during the 1993 and 1996 trials, could have changed the outcome. Maybe not to acquittal, but perhaps to manslaughter or a lesser charge. The defense says the jury was never allowed to fully understand the fear these young men were allegedly living in, and that now, with outside confirmation of abuse, the legal system has a duty to revisit the case. The prosecution, of course, disagrees. They've already filed responses pushing back on the new trial motion, calling it a rehash of old arguments wrapped in new paper. They say the letter isn't new enough, and the outside abuse allegations are unrelated to the Menendez brothers' specific situation. That motion hasn't been ruled on yet, and it likely won't be anytime soon, but it's there, lurking in the background. A third path, a backdoor that could, in theory, blow the whole thing wide open. So right now, the Menendez brothers are standing at a kind of legal crossroads. In one direction, the resentencing hearing and the chance to reduce their punishment under new laws. In another, clemency from the governor, backed by a risk assessment that could open the door to parole. And in a third, the long-shot bid for a new trial fueled by evidence that wasn't available when the verdicts were handed down. For decades, the Menendez case has been frozen in place. 2 guilty verdicts, 2 life sentences, and no room to move. But in 2025, all 3 of these legal tracks are moving at once. And for the first time since the words "life without parole" were read into the record, there's movement, there's noise, there's possibility. What happens next? Well, that depends on what these systems decide. The court, the governor, the law, all 3 are in motion, and all 3 are heading straight for a decision point that could change everything or nothing.
In a world where the darkest secrets lie just beneath the surface.
So they said it was an accident, but the evidence says otherwise.
Where hidden killers roam, unnoticed, in the shadows.
I think you would definitely be looking at a blend of toxic, very bad narcissistic personality traits, and they will be vengeful and possibly resort to violence.
Join Tony Bruschi as he uncovers the truth behind the most chilling cases.
They said it was an accident, but the evidence clearly says otherwise.
Each episode, we dig deep into the minds of those who commit the unthinkable.
To your point on narcissism, he thinks in his own mind how witty he is.
Yeah.
But he lost that jury. I was done with him in 2 minutes.
From unsolved mysteries to infamous crimes.
Geez, you've just talked about how you've taught yourself how to do everything under the sun. I bet you did a YouTube video, how to best kill somebody with a knife.
Hidden Killers with Tony Bruschi takes you where few dare to go.
How does someone with such a dark secret go unnoticed for so long?
With multiple new episodes every single day.
We're not just telling stories, we're seeking justice.
Listen now on Apple Podcasts or wherever you get your podcasts. Just search for Hidden Killers with Tony Bruschi.